Well, welcome back to Labor and Employment Law, Legal 267. My name's Scott Haddock. I'm the professor for this class, and you're at Edmonds College's wonderful ABA-approved paralegal program. And today we're on our third of four lectures. This is called Leave Law in Washington, FMLA, PFML, and Workplace Coordination. So we now move into one of the most practical and sometimes frustrating areas of employment law, leave. Leave law can feel complicated, but not because any single rule is impossible to understand. It feels complicated because multiple systems often apply at the same time. You may have federal law under the Family and Medical Leave Act, or FMLA. You may have Washington Paid Family and Medical Leave, or PFML. You may also have employer policies, collective bargaining agreement provisions, disability accommodation obligations, pregnancy accommodation requirements, and retaliation protections layered on top of those systems. So the first question is not simply, does the employee need time off? The better legal question is, which law governs what? One law may provide job protection, another law may provide wage replacement, and another still may create an accommodation duty, and yet another may create a retaliation claim if the employer responds improperly. And that's why leave law is really a coordination problem. For paralegals, this is where careful organization matters. You're often helping the legal team identify which systems apply, what notices were sent, what deadlines are important, what documentation exists, and whether the employer treated the leave request correctly. And the key point for this lecture is pretty simple. In Washington, you cannot analyze leave by looking only at the FMLA. You have to check both the federal system and the Washington state system. So let's start with that federal system first. The federal anchor is the Family and Medical Leave Act. The FMLA provides eligible employees with up to 12 weeks of leave for qualifying family or medical reasons. But we need to be careful with that sentence. FMLA does not apply to every workspace, every employee, or every leave request. First, the employer must be covered. Second, the employee must be eligible. And third, the reason for the leave must qualify under the statute. When FMLA applies, the leave is generally unpaid, but it is job protected, and the job protection is the key feature. The employee generally has the right to return to the same position or an equivalent position after protected leave ends. Now, for paralegals, the first FMLA task is eligibility screening. You may want to know the employer's size, the employee's work site, the employee's length of employment, the number of hours they worked, and the reason for the leave. You'll also want to collect the employer's notices, any medical certification forms, leave approval or denial letters, attendance records, and return to work communications. That information really helps the legal team determine whether the employer correctly applied the FMLA statutory framework. But FMLA is only the federal baseline. In Washington state, the analysis doesn't stop there. So now we turn to Washington's separate paid leave system. Washington state has its own paid leave system. It's called the Paid Family and Medical Leave, PFML. That's a lot of acronyms. I know that for a fact. It gets a little annoying, but the PFML is governed by Title 50A of the Revised Code of Washington. And this is a state-administered benefit program, and it's handled through the Washington Employment Security Department. That's a major difference from the FMLA. The FMLA is primarily about unpaid job-protected leave, but Washington's PFML is about partial wage replacement for qualifying family and medical leave. In practical terms, the employee applies through the state system for paid leave benefits. That means the legal team may need to review the employee's PFML application, benefit approval or denial, state notices, employer communications, and any workplace decisions that occurred before, during, or after the leave. But PFML is not just paid FMLA. That's a mistake that students should avoid. The PFML has its own eligibility rules, its own procedures, its own benefit system, and as we'll see in a moment, its own job protection rules. So when a Washington employee requests leave, the correct question is not, does FMLA apply? The correct question is, which systems apply and what does each system provide? Remember, the FMLA may provide federal job protection, but the PFML may provide wage replacement. Washington law may also provide state job protection. And other laws, such as the WLAD, may create accommodation or retaliation protections. And that brings us to one of the most important Washington updates. Now, this slide you're seeing right here is one of the most important practical points in this lecture. Starting this year, January 1st, 2026, Washington expanded job protection for many employees who used paid family and medical leave. This is important because students often associate job protection only with the FMLA, and that's no longer enough in Washington. Under the federal FMLA, an employee generally must satisfy several eligibility requirements, including the familiar 1,250-hour requirement. But Washington's PFML job protection has its own state law structure. And starting on January 1st, 2026, many Washington employees may have job protection under the PFML if they work for an employer with 25 or more Washington employees and have worked for that employer for at least 180 days. Here's a critical distinction. Washington PFML job protection does not use that federal 1,250-hour requirement. That's a huge practical point. An employee might not qualify for FMLA job protection, but may still have job protection under Washington's PFML. So you cannot stop after asking, does this person qualify for FMLA? You have to ask, does this person qualify for Washington PFML job protection? If PFML job protection does apply, restoration rights may apply as well. The employee may have the right to return to the same or equivalent position after protected leave. Health benefits may also need to continue depending on the circumstances. Now, for paralegals, this means eligibility screening has to be precise. You want to know the employer's size, the number of Washington state employees, the employee's start date, whether the employee applied for PMFL, whether FMLA also applies, what notices were sent, and what happens when the employee tried to return. And the practical rule here is simple. Check FMLA and PFML separately. Failure to qualify under FMLA does not automatically end job protection analysis in Washington state. Now let's look at how the two systems operate together. Okay, so let's put these two systems together. The FMLA and the Washington PFML can overlap, but they're not identical. FMLA is the federal law. It provides unpaid, job-protected leave when the employer is covered, the employee is eligible, and the leave reason qualifies. Washington PFML is state law. It provides partial wage replacement through the Employment Security Department, and when state job protection requirements are met, it may also provide restoration of your job rights. Sometimes the same leave event qualifies under both systems. For example, an employee who has a serious health condition may qualify for FMLA leave and may also apply for PFML benefits. When the same leave qualifies under both the FMLA and the PFML, the leave may run concurrently. That means the same period of absence may count under both systems. but the employer still has to track each system because the rights, benefits, eligibility rules, notices, and procedures are not identical. PFML wage benefit eligibility and PFML job protection are related, but they're not the same question. An employee may qualify for wage replacement through the state system, but the legal team still has to ask separately whether the employee also has job protection, and that's a really important distinction. Don't assume that approved for PFML benefits automatically answers the job protection category. And don't assume that not eligible for FMLA automatically means not protected. This is where employers can make a lot of mistakes. The employer may correctly conclude that FMLA does not apply, but then fail to consider PFML job protection. Or the employer may recognize PFML wage benefits, but misunderstand whether the employee also has restoration rights. Or the employer may approve leave, but later discipline the employee for absences that should have been protected. Now, for you paralegals, the best approach is to build a leave map. A leave map. For each leave event, identify the following: what law applies, what benefit applies, what job protection applies, what notices were required, and what documents were exchanged, and what happened after the employee requested or used the leave. This map, this leave map, is often what follows the legal team to see, or allows the legal team to see whether the employer coordinated the system correctly. Now next, let's focus on the documents and process steps that make or break these cases. As you've already probably figured out, leave law is extremely process driven. That means documentation matters. For Washington PFML, employees generally must provide at least 30 days notice if the leave is foreseeable. Now, if the leave is not foreseeable, notice must be given as soon as practicable. That distinction is important because not all leave can be planned. A scheduled surgery may be foreseeable, but a sudden medical emergency usually is not. Intermittent leave also requires careful tracking. Starting in 2026, Family PFML uses a minimum claim duration of 4 consecutive hours for intermittent leave. That means the legal team needs accurate records showing when leave was used, how it was recorded, and whether the employer treated the leave properly. Written notices are also important. Employers may need to communicate whether the employee's leave is job protected, when job protection is expected to expire, what restoration rights may apply, and whether health benefits will continue. That may sound technical, and it is, but this is where legal rights become real workplace procedures. The paperwork tells everyone what system is being used, what rights apply, and what happens next. Now, from a paralegal perspective, this is where you build the paper trail. You would want to collect the leave request, the PFML application or approval, employer notices, medical certification or supporting documents, attendance records, payroll records, benefits communications, discipline records, return to work communications, and any messages from supervisors or human resources. The legal issue may be whether the employee had a right to leave, but the evidence often comes from the paperwork showing how the request was handled. Now let's look at the common mistakes that create legal risk. Many leave disputes begin with coordination errors. An employer may look only at FMLA and stop there. That's a problem in Washington because PFML may create separate rights. An employer may miss PFML job protection, especially when the employee does not meet the federal 1,250-hour requirement, but does meet Washington's 180-day rule. An employer may fail to give required notices or may give confusing notices that do not clearly explain the employee's rights. Intermittent leave can also create problems. If the employer tracks intermittent leave incorrectly, the employee may appear to have attendance problems when the absences should have been protected. Another common issue is treating protected leave as misconduct. For example, an employer might discipline an employee for absences that were connected to approved leave. Or a supervisor might become frustrated with an employee's medical leave and begin documenting performance concerns only after the leave request. That doesn't automatically prove retaliation, but it does create a fact pattern the legal team needs to examine very carefully. In practice, many leave cases become retaliation cases because the legal question shifts. At first, the question may be, did the employee need leave? But later the question becomes, did the employer treat the employee worse because the employee requested leave, used leave, or tried to return from leave? And that shift is important. The leave request itself may become protected activity. The employer's response after the request may become the evidence. Employers can also miss the overlap with pregnancy and disability law. The leave request may also be a request for accommodation. A pregnancy-related limitation may trigger pregnancy accommodation duties. A medical condition may trigger disability accommodation obligations under WLAD. And so the core risk is this. A leave issue can become a discrimination, accommodation, interference, restoration, or retaliation claim. For paralegals, the practical job is to identify those risk points early and organize the facts so that the attorney can see which legal theories may apply. And that brings us directly back to the WLAD. Washington state leave issues often overlap with the Washington law against discrimination. The WLAD, as you know, is codified at RCW 49.60. You've already seen WLAD in earlier lectures as Washington's primary employment discrimination statute. In leave cases, the WLAD is important because the need for leave may be connected to a protected status or protected activity. A medical condition may raise disability accommodation issues. A pregnancy-related limitation may raise pregnancy accommodation or sex discrimination issues. A leave request may be followed by discipline, demotion, termination, or hostility from a supervisor, and that may raise retaliation concerns. The key question is this the only leave issue, or is it also a discrimination or retaliation issue as well? For example, imagine an employee requests medical leave, receives approval, and then returns to work. 2 weeks later, the employee is written up for reliability concerns, quote unquote. That might be legitimate, but it also might require closer review. What did the employer count as unreliable? Were protected absences included in that? Were other employees treated differently? Did the supervisor make comments about the leave? Did the employer follow the usual process? Did the timing suggest retaliation? These are the kinds of questions that move a case from basic leave administration into employment litigation analysis. This is also why paralegals' work is so important. You help build the timeline, compare the documents, identify inconsistencies, and you flag where the employer's explanation may not match the record. Let's make this concrete with a Washington practice example. Okay, let's apply the framework. Imagine an employee works for a Washington employer with 35 Washington employees. The employee has worked there for 8 months. The employee develops a serious medical condition and needs to take intermittent leave. The employee applies for Washington PFML. The employer responds by saying, quote, "You are not protected because you have not worked 1,250 hours, so you do not qualify for FMLA," unquote. That statement may be partly correct, but legally incomplete. And you can see why. The employee may not qualify for FMLA job protection if the federal eligibility requirements aren't met, but that does not end the analysis, as you know, because starting in 2026, Washington's PFML job protection may apply if the employer has at least 25 employees and the employee has worked for the employer for at least 180 days. In this example, the employer has 35 Washington employees, and the employee has worked for 8 months. That means Washington PFML job protection may still apply even if the FMLA does not. This is exactly the kind of mistake that can happen in practice. The employer uses the FMLA framework as if it controls the whole issue, but in Washington it doesn't. The correct analysis requires separate review of the FMLA eligibility, PFML wage benefits, PFML job protection, and any related accommodation or retaliation concerns that might exist. Now, for paralegals, this is where your timeline and eligibility chart become essential. You would want to document the employee's start date, the employer size, the leave dates, the PFML application, the employer's response, any attendance points, any discipline, and the return to work communications. The answer is not just found in one statute. It comes from coordinating the entire leave record. Let's close by turning that into practical workflow and a review. Okay, let's bring this all together. In leave cases, paralegals play a central role because these cases are built through documents, timelines, notices, and process history. The first step is to identify each applicable law. Is this FMLA? Is this Washington PFML? Is this employer policy? Is it pregnancy accommodation issues or a disability accommodation issue? Was there possible retaliation? The second step is to screen eligibility separately. Don't assume that one eligibility answer resolves everything. For example, an employee may fail FMLA eligibility but still have PFML rights. An employee may receive PFML wage benefits but still need a separate analysis of job protection. An employee may need leave and accommodation at the same time. Now, the third step is to build the leave timeline. The timeline should answer the following questions. When did the need for leave arise? When did the employee notify the employer? Was the leave foreseeable or unexpected? When did the employee apply for PFML? What did the employer say? What documents were exchanged? When was leave used? And was the leave continuous or intermittent? What happened after the employee returned or attempted to return? These timeline questions are not just administrative. They can determine whether the employer handled the leave correctly, whether protected leave was treated as an attendance problem, or whether later discipline or termination may be connected to the leave request. The fourth step is to gather the documents. In these cases, the documents often tell the story. You want the leave request, PFML records, FMLA notices, medical certifications, HR communications, attendance records, payroll records, benefits records, discipline records, and return to work materials. You want all of those. The fifth step is to identify the forum and the process. This is where we return to a framework from the beginning of the course. The forum matters because it determines the procedure. A PFML benefit dispute may involve the Washington Employment Security Department. The FMLA interference or retaliation claim may follow a federal litigation pathway. A WLAD discrimination, accommodation, or retaliation claim may involve the Washington State Human Rights Commission, direct court litigation, or both, depending on the strategy and the timing. Pregnancy and disability accommodation issues may involve their own Washington law protections and enforcement routes that we talked about, at least for pregnancy, in our last lecture. So one leave event can generate several different legal pathways, And that's why the legal team cannot simply say, this is a leave case, and stop there. You have to ask which law applies, who enforces it, what process governs it, what deadline matters, what remedies available, and what documents prove what happened. So the final takeaway is this. Leave law is law plus procedure plus documentation. I'll repeat that. Leave law is law plus procedure plus documentation. It's not enough to know the rule. You have to know which system applies, who enforces it, what process must be followed, and what documents show. That's exactly where skilled paralegals add tremendous value. They help the legal team see the structure, they preserve the evidence, and avoid missing the legal significance of what may look like an ordinary workplace paperwork trail. In Washington leave cases, the strongest analysis comes from careful coordination. Check every system, build the timeline, preserve the documents, and always ask whether the leave issue has also become a job protection, accommodation, discrimination, or retaliation issue.